We can move on now to alternative dispute resolution. And this is the third way we can improve access to justice. So far, we've looked at making law simpler, we've looked at making help cheaper or more affordable, and now we're going to look at ways to move things out of the courts, to provide alternative ways for people to resolve their legal problems, and in doing so, a way to provide alternative access to justice. Alternative dispute resolution, or ADR, is an approach to legal disputes that tries to move these disputes out of the courtroom, tries to move them out of the adversarial justice system. ADR is supposed to be a more user-friendly and less adversarial system of justice. What it tries to do is expand the pie, provide innovative solutions that are to the satisfaction of all parties, or as far as possible to the satisfaction of all parties, and try to do this rather than declare a winner and a loser. So adversarial justice systems are often just about a winner and a loser, and ADR tries to change that dynamic. It also tries to be flexible. So rather than just having a judge interpret the meaning of a contract, an ADR provider might look at what the parties want, what the parties need, and be more flexible in the remedy it provides. ADR is really important because the justice system's caseload is resulting in courts being really stretched in terms of their resources to hear cases. So ADR is an important alternative route. Also for the parties, with the limited availability of legal aid, court proceedings might be actually beyond a party's financial reach. ADR might be available. And then if we kind of add on the prospect of better results from a more flexible justice system, ADR starts to look pretty great. But we should hold off celebrating just yet. The origins of ADR were as an opt-in system. However, as it's become increasingly important and increasingly necessary, really, we're starting to see more and more mandatory ADR. So in some contexts, ADR can be ordered by courts, or it can be compulsory. So a good example of that is mandatory mediation in some family matters. There are a few different kinds of ADR that I want to introduce you to today, and the first is arbitration. Arbitration is adversarial ADR, actually, but it still gets the dispute out of the courtroom. An independent third party arbitrates the dispute, with parties choosing the arbitrator, the process, and the forum. That means the parties can choose a subject matter expert to resolve their dispute for them, or they could choose someone who they think doesn't have any perceived biases that they might think a judge would. Choice of forum, choice of process means that parties can avoid the adversarial courtrooms and do things a bit differently. They can keep things quicker and cheaper. They can also try and keep things confidential. And where parties have agreed to arbitration, the outcome of that arbitration, what we call the arbitration award, is enforceable. So the parties get their resolution to a legal problem without having to argue their case out in court. Then we have mediation. In mediation, an independent third party, the mediator, helps the parties to resolve the dispute themselves. So what the mediator does is provide supervision and provide structure to the parties' negotiations, and the mediator tries to help those parties to reach an agreement. Proceedings can be confidential, they can be cheap, and they can be quick. We see two main forms of mediation. The first is what's called evaluative mediation, and in that form the mediator is a bit more involved, in that the mediator assesses the strength of the parties' arguments. So the mediator has a kind of evaluating function, not like a judge, not like an arbitrator, but they can evaluate the strength of claims to help the parties reach agreement. The other type of mediation is what's called facilitative mediation, and that's where the mediator just helps the parties to resolve the dispute, to reach a solution themselves. They don't have that evaluating function. Conciliation is similar to mediation, but when we have a third-party conciliator, they're going to play a bit more of an active role. A conciliator in conciliation processes will direct parties towards resolving their legal dispute by proposing different solutions for them to adopt. So the conciliator gives the parties some ideas, gives them some solutions and says, why don't you try this? And we could compare that with a mediator who's more about facilitating parties to develop their own solutions. That's the distinction here. Arbitration, mediation, and conciliation, they are all forms of ADR that move disputes out of the courtroom. In doing so, they provide alternative access to justice through forums that aren't part of the adversarial justice system. In doing so, they can avoid some of the problems associated with that system. And there are a number of advantages here. There are a number of advantages to ADR. That less adversarial nature that ADR has inherently is actually capable of maintaining and maybe even improving parties' relationships. ADR can also increase the options available to parties. It can allow them to choose solutions for themselves. And I mentioned just a few minutes earlier the idea of expanding the pie. This is the idea of producing a better solution for both parties through a more flexible process. It's this idea of allowing for more creative as well as more appropriate remedies. Courts are often accused of doing what's called splitting the pie, of dividing the case up to create one winner and one loser as part of that adversarial justice system. And ADR can avoid that. That's why we talk about it, expanding the pie. ADR can be faster, it can be cheaper, it can cost less, and ADR is also often well received by participants when they actually use ADR. However, there are also a number of problems associated with ADR, and these are important to note. One of those, and maybe the most important, is that ADR is arguably not able to deal with imbalances of power between parties. Now, obviously there are questions too about whether courts can do this, but ADR, with its focus on the interaction between parties, on the relationship between parties and parties working together to come to a solution, that focus really brings to the fore the risks of one party overbearing the other. And there could be a number of different reasons why that could happen. They might be economic reasons, they might be interpersonal reasons. There are all sorts of reasons why one party could dominate the other in an ADR process. There are also questions of expertise when we look at ADR. There are questions about whether those people who provide ADR services are actually best equipped to deal with the range of issues that can arise in these disputes. And those might be legal issues, or they might be non-legal issues. They might be interpersonal issues or economic issues. You have to have a lot of expertise if you're going to provide really good, effective ADR services. There's also difficulties of enforcement sometimes. So sometimes you do end up with court involvement in the dispute just later down the line. And these different problems might explain why there is a relatively low take-up of ADR, why it's relatively unpopular before people actually use it. It's also important to recognize that ADR processes, ADR systems, can't set precedent in the way that court judgments can. So this has consequences for the way ADR can function, but it's also important when we think about the justice system more generally. ADR can't contribute to the body of law that the justice system produces in the same way that courts and cases can. Owen Fiss has argued strongly against ADR and against settlement. He describes settlement as a capitulation to the conditions of mass society that should neither be encouraged nor praised. So, according to Fiss, there's a critical difference between a process like settlement, which is based on bargaining, that's the thing, ADR is all about bargaining, and accepts inequalities of wealth as an integral and legitimate component of the process, and a process like judgment, which knowingly struggles against those inequalities. Fiss was of the opinion that when parties settle, society gets less than what appears, and for a price it does not know it is paying. Parties might settle while leaving justice undone. So, because ADR proceedings often take place behind closed doors, there are questions about what impact ADR has on the system of justice. Cases are being taken outside of the courts, which means we're less aware of what legal issues are arising because we don't have that public forum in which we can see these legal issues arise. And also the law gets less opportunities to develop through precedent, through bringing these cases into the spotlight, and through judges figuring out what the right answer is here. Of course, we could make the same criticisms of adversarial proceedings. We could say that they don't go far enough in preventing inequalities of wealth from affecting the outcome of disputes. We could say that they don't go far enough in ensuring society gets justice. But this is a problem we need to be aware of in the context of ADR. But that wraps this lecture up. Access to justice is really important as an element of justice and fairness in society, as an element of law. If some people can't get the knowledge, the forum, or the support they need to solve legal problems, then the justice system is failing those people. There are a range of options available for improving access to justice, a lot of which we can see in action in Australia, but that doesn't mean that problems with cost, speed, and quality of dispute resolution in Australia are all fixed. Australia, like a lot of places, is still a work in progress when it comes to access to justice. Thanks for listening.